almost never seen, and the judge was not solely focused on Ms. Halligan, but focused on the FBI's wholesale abuse of the Fourth Amendment and their rummaging around in privileged information and mishandling of the privileged information. That alone would be a basis to exclude evidence, but it's also a basis, given how intentional it was, as the judge noted, given the fact that the FBI general counsel and the agent who went into the grand jury were both informed prior to the grand jury appearance that they had been exposed to serious privileged information, and they used that to shape their presentation to the grand jury. That's fundamentally wrong. But also on the Halligan point, her time in the grand jury is extraordinary. She told the grand jury basically that Comey didn't have a Fifth Amendment right at trial to refuse to testify, and therefore he would be able to, give his explanation as to the events and counter the government's evidence, which the judge noted appropriately was burden shifting. And moreover, she told the grand jury in an extraordinary statement that not to worry about the record with which they had been presented because the government had better evidence at trial. That's like saying, please indict this person because we don't have time to indict innocent people. It's just way, way, way out of bounds. And frankly, it would be a basis to have her disbarred. And because Pam Bondi twice affirmed the legitimacy of her presentation, it would be a basis to have Bondi disbarred as well.
Stunning. Which is really stunning. I mean, we know Halligan, of course, had not prosecuted a case before this, but to say, as you did, to put it in black and white, what the implications of that could be both for her and Pam Bondi, it is stunning. I want to ask you one other thing, Ty. Yeah, go ahead.
Aaron, if you don't mind, there is one other extraordinary event here, which is there's a missing 2 hours and 20 minutes, which puts Rosemary Woods
in the grand jury
17 minutes. Yes, and keep in mind that included the rejection of the government's initial indictment and the submission of a second indictment. There's no record of that, and the judge makes the point it's impossible to believe that there weren't communications between her and the grand jury. Where are they?
Our indictments speak powerfully in court. If you don't believe us, just look at the response that the Eastern District of Virginia under Lindsay Halligan did to James Comey, and look at the notes and publication of evidence. That's the type of material we have, but we have to safeguard our prosecutions because the ultimate accountability is with the verdict in a jury room.
For once, we agree with Kash Patel. Hi again, everybody. It's 5 o'clock now in New York, meaning a strict new deadline just passed moments ago for the Trump Justice Department, whose indictments, as you just heard, in their view, speak powerfully in court. Until they don't. Because this afternoon, in a rare and remarkable ruling, a federal judge in Virginia ordered the government, the Trump Justice Department, to hand over the grand jury materials, including audio, in the criminal case against former director of the FBI, Jim Comey. Now, why did the judge do that? Well, he explains, because there are evidently, quote, genuine issues of misconduct, end quote, issues apparently so serious that Comey could see his charges dismissed altogether. In his ruling, for which the DOJ sought an emergency stay, U.S. Magistrate Judge William Fitzpatrick noted how rare it is to allow a defendant access to grand jury materials. However, he says, quote, the record points to a disturbing pattern of profound investigative missteps that led an FBI agent and a prosecutor to potentially undermine the integrity of the grand jury proceeding, end quote. Of course, the official presiding over this, quote, disturbing pattern is the aforementioned interim U.S. Attorney Lindsay Halligan, a Trump-appointed official who had never prosecuted a case before prior to this one, when she overruled the objections of career prosecutors in that office. More from today's opinion from the judge, quote, this unusual series of events, still not fully explained by the prosecutor's declaration, calls into question the presumption of regularity, generally associated with grand jury proceedings, and provides another genuine issue the defense may raise to challenge the manner in which the government obtained the indictment. All of this lines up perfectly with what is the most comprehensive reporting to date of the troubling atmosphere inside Donald Trump's Department of Justice right now. The New York Times interviewed more than 60 attorneys from the agency, either recently resigned or recently fired. The picture they paint is genuinely horrifying for anyone who appreciates the rule of law or appreciated. A former lawyer in the Civil Rights Division told the New York Times this, quote, "I wouldn't even call it the Justice Department anymore. It has become Donald Trump's personal law firm. I think Americans should be enraged. We all deserve better than this. I keep telling my colleagues still working in the division that I'm holding the line with them from the outside, but I feel guilty that I'm not holding the line with them from the inside." That is where we begin the hour with some of our favorite experts and friends. Former Assistant Special Agent in charge at the FBI and National Security and Intelligence Analyst Michael Feinberg is back with us. He's also a fellow at Lawfare. Also joining us, former top official at the Department of Justice and legal analyst Andrew Weissman's here. Let me start with the judge's extraordinary wording. And this is something I delved into, I believe, with both of you last week on the questions around what was presented to the grand jury in the Comey case to reach an indictment after Eric Siebert, who was MAGA adjacent, MAGA in good standing with Pam Bondi and Todd Blanche, but resigned over this case, saying there wasn't enough evidence to take it to a grand jury and reach an indictment. Lindsay Halligan comes in. We played Kash Patel, toasting her, feeding her, and pointing to the results. The result of Lindsay Halligan so far from this judge is failing marks. Andrew Weissman, explain.
Well, some of this is the result of in the grand jury. You would think that Lindsay Halligan, who has no criminal experience until she took on this role, you would think that somebody would have gone into the grand jury with her. Instead, we know from the judge's opinion that she went in alone. And so part of what the judge called out here was at least two things that she said that are partially redacted, meaning we don't see all of it, that he says are highly problematic and thus justify giving the grand jury transcript to the defense so they can make motions about it. But that's sort of like Keystone Cops stuff. The idea that we know that nobody in the Eastern District of Virginia no career person was willing to do this. But you think somebody at Main Justice would have said, we're going to send somebody with some experience in there. Let's just for a moment think that we were dealing with a defendant who was guilty of something really serious, like a terrorism offense. Is this what you want from your FBI and your Justice Department? Is the kind of violations that the judge calls out here and says that there is probable cause to find. And you see this sort of what I think is sort of reminiscent of what we saw with the Charlie Kirk investigation, where the FBI and the American public and Charlie Kirk's family got lucky. It wasn't because the FBI and the Justice Department were doing a good job. And you're seeing that play out here, which is just rookie mistakes. And to be clear, rookie mistakes that this judge says have all of the look and feel of violating the Constitution and the attorney-client privilege of James Comey. So this is more to come, but incredibly serious allegations by the judge here.
Is it enough, Andrew, to get the case dismissed?
It may be enough to dismiss the indictment. There are other grounds as well, such as the appointment of Lindsay Halligan, but it also signals to me that there are going to be at least very colorable, if not winning, arguments to suppress evidence. The judge calls out a Fourth Amendment violation here. It remains to be seen how big a taint that is and whether the government has some arguments on the other side. But if you just get evidence suppressed, and there isn't a lot of it here, there's very, very little evidence. That's why you have all these career people and even Mr. Seibert saying we don't want to bring this case. But if you actually violated the Fourth Amendment, then the judge is free to say we are suppressing that evidence, and you need to have evidence in order to actually go to a trial.
This trial for Trump is different than his usual ones. He's had ones like this before because Trump fundamentally has no respect for law and order, justice, the proper functioning of the system, and so on. But you have to make clear there's a difference between losing in court and what happened today. because good faith losses happen all the time in a court system, whether civil or criminal. You might legitimately think you were wronged in a civil case, and you might sue someone, but you're not doing it to silence them or censor them. You're not doing it to bully them or to use the legal system as a cudgel. You legitimately feel that you were wronged, and you go through a trial and you lose because you weren't wronged, or they found you weren't wronged, at least according to a judge and or jury. And the judge usually doesn't fully punish you. You're not always asked to pay the legal fees. You're not held in contempt. The judge doesn't yell at you or scold you because sometimes in the legal system, people are in good faith and they try their best, and they lose. It happens with prosecution sometimes. Sometimes you bring charges against somebody, and the prosecutor wasn't railroading somebody. They weren't trying to screw anybody or racially profile somebody or whatever, but they lose. They weren't able to prove guilt beyond a reasonable doubt. The jury felt that they didn't make the case, not that they were being corrupt. Here though, what you're seeing is the judge say, "No, no, no. This is really bad." And I'm seeing a lot of signs here that this was not a fair process. Not only do I feel like maybe you made a mistake bringing these charges, but the moves are bad enough that I might dismiss the case outright. I feel like you may have railroaded Mr. Comey to try to get him, that his claims that this was a political prosecution, that it was vindictive, that the way the grand jury was operating, the way the DOJ rep was operating was not fair. And I'm seeing some inkling of that. And for the judge to even mention that, let alone proclaim it, showcases just how dirty Trump is.